All right, welcome everyone to Understanding the Basics of Food Labeling. My name is Audrey Thompson and I'm a staff attorney here with the Penn State Center for Agricultural and Shale Law. Today's webinar is part of the center's Understanding Agricultural Law series, a course designed to provide subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent agricultural or rural clients, but who may not necessarily specialize in agricultural law. This series is wholly sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center, established through the 2019 Pennsylvania Farm Bill. The Ag Business Development Center aims to enhance the long-term vitality of Pennsylvania farms by supporting farm transitions, both from generation to generation and from conventional to organic farming, supporting beginning farmers, providing risk management, education, and providing financial assistance through low-interest loans and grants. Next slide, please. As you can see here, we have covered numerous topics so far, including ag labor and the Fair Labor Standards Act, ag cooperatives finance and the farm credit system, crop insurance, conservation programs, Pennsylvania's Clean and Green program, and many, many more. You can find materials and recordings from all of these webinars on our Understanding Agricultural Law landing page on our website at aglaw.psu.edu. Next slide. Upcoming topics in our Understanding the Basics of Ag Law series include clean and green separations and split-offs. This is going to be our first semi-advanced topic. We do have a Understanding the Basics of Clean and Green webinar. This is going to be diving deeper into that topic. We're going to talk about separations and split-offs, leasing, subdividing, or selling enrolled land. We're also going to do organic production in March, and then in April, producer protections for buyer default. These are all on Fridays. They're all at noon, and registration is up and available for all of them on our events page on our website. I will also mention some other programming we have coming up in February. We've got the overview of the Pennsylvania Milk Marketing Law beyond the overorder premium in February. And then in April, we've got overview of U.S. state milk pricing systems. That's part of our dairy quarterly legal webinar series. And then in March, we are partnering again with the Pennsylvania Agricultural Ombudsman Program to offer another AGR presentation. That's going to be called Agriculture, Local Regulations, and Nutrient Management. And that will feature Rob Willig, the Senior Deputy Attorney General from the Pennsylvania Office of Attorney General, and Robert Minen, Assistant Research Professor with Penn State Extension, and our own Senior Staff Attorney, Brooke Doerr. That will be in person at the U.S. Hotel Tavern in Hollidaysburg. All right, I will now turn this webinar over to Chloe Marie. Chloe is a research specialist at the Penn State Center for Agricultural and Shale Law. She holds a Bachelor of Science and Master of Law degrees from the University of Paris in France, and LLM from Penn State Dickinson Law with a focus on energy and natural resources. Chloe is the principal contributor to and manager of the center's issue trackers and virtual resource rooms, which include compilations on the bioengineered food disclosure, cell-cultured food regulations, meat labeling laws, and the Food Safety Modernization Act. Chloe, the screen is yours.
Thank you, Audrey. And welcome everyone to our webinar on the basics of food labeling. So before we start, food labeling is a very vast topic, and I realized when I was prepping for this webinar that I could not possibly cover everything in just 1 hour. You know, each aspect of food labeling could be discussed at length. So today we'll just scratch the surface and give you a general overview of food labeling principles and practices. We won't address the exemptions and exceptions for each rule, but we'll cover the basics and give you a good foundation for understanding this trending topic. That being said, I will first start by addressing the roles of the U.S. Food and Drug Administration and U.S. Department of Agriculture in regulating food labeling. The Alcohol and Tobacco Tax and Trade Bureau regulates the labeling of alcoholic beverages. However, we'll focus exclusively on food and soft beverages labeling rules for the purpose of this presentation. We'll go briefly over the rules governing the labeling of a food product's geographic origin. Then we'll discuss the food labeling requirements and label claims for conventional foods and dietary supplements. So these label claims include nutrient content, health, and structure/function claims, as well as other statement claims such as organic and animal welfare certifications, natural food and gluten-free claims, and bioengineered food disclosure. And to round up our discussion, we'll address the labeling standards for plant-based food alternatives, particularly the FDA 2023 draft labeling recommendations for plant-based milk alternatives. And finally, we'll discuss the deceptive food labeling and claims and the legal parameters for deeming a food product misbranded. Let's start. So, in the US, the US FDA and the USDA share primary responsibility for regulating food labeling. The USDA Food Safety Inspection Service regulates the labeling of meat, poultry, and egg products under the Federal Meat Inspection Act, the Poultry Products Inspection Act, and the Egg Products Inspection Act, while the FDA regulates the labeling of other food products and food ingredients under the Food, Drug, and Cosmetic Act. However, let's note that the FDA does not need to pre-approve labels for food products. So the information required on labels for meat, poultry, and egg products under FSIS guidelines are pretty much the same as those set by the FDA for other food products, with the exceptions of a few differences, and we'll go over those specific differences once we start reviewing the food labeling requirements. So the principal display panel is the most prominent part of a food product's packaging. It is the product's front face, the first thing that customers will see when picking up a product. And the PDP is required to display the statement of identity and net quantity of contains statements. It is often accompanied by an information panel if there is not enough room on the PDP, and must be located directly to the right of the PDP. This panel serves as a supplement to the PDP and may include the ingredient list, the manufacturer or distributor information, the nutrition facts panel, allergen information, as well as nutrient, health, and or structure/function claims, and any other relevant labeling claims. Meat and poultry products must have a USDA inspection mark with the establishment number, as well as handling statements displayed on the PDP. A handling statement is meant to inform consumers about how to properly store and handle the product to ensure its safety and freshness. So the statements such as keep refrigerated, keep frozen, perishable, must be placed prominently on the PDP. And in addition, safe handling instructions are mandatory for raw or partially cooked meat and poultry products. And before I go over the specifics of the label itself, I'd like to talk about the rules concerning the origin of the food product. So the country of origin labeling regulations require retail food stores to inform consumers about the country of origin of certain foods, including lamb, chicken, goat meat, wild and farm-raised fish and shellfish, perishable agricultural commodities, including fresh and frozen fruits and vegetables, macadamia nuts, pecans, peanuts, and ginseng. The Food Safety Inspection Service requires that imported meat and poultry products must clearly indicate the country of origin, followed by the phrase product of X country. The country of origin statement must be placed directly under the product name. And in addition, the U.S. Customs and Border Protection requires that all items imported into the United States from foreign countries must be labeled with the country of origin in English, unless exempted by specific regulations. Also, a quick word about product of USA claims for food. Product of USA claims are voluntary, and according to the FSIS Food Standards and Labeling Policy Book, meat, poultry, and egg products that may have been born, raised, and slaughtered in another country, but are minimally processed in the US, may bear the label designation product of USA. Now, in March 2023, however, the Food Safety and Inspection Service proposed to change its rules about how food companies can label animal products as product of USA, explaining that the current rules are confusing to consumers. So the rule would authorize for two specific voluntary US origin label claims to be used on meat, poultry, and egg products. product of USA, and made in the USA. So these claims would be allowed for single ingredient products derived from animal born, raised, slaughtered, and processed in the US. And for multi-ingredient products, these claims will still be allowed if all FSIS regulated products are derived from animals born, raised, slaughtered, and processed in the US, and all additional ingredients other than spices and flavorings are of domestic origin. Additionally, the rule would allow for qualified claims to be used on products that do not meet the criteria for the authorized claims. These qualified claims would need to include description of the preparation and processing steps that occurred in the US. For example, sliced and packaged in the United States using imported pork. So the comment period for that rule ended in May 2023, so stay tuned. And for other food products, manufacturers and retailers must comply with the Federal Trade Commission's enforcement rules on US origin claims. The Commission protects consumers from deceptive and misleading advertising, including food advertising, and requires that a product labeled Made in USA be, I quote, all or virtually all made in the US. This means that all significant parts and processing that go into the product must be of US origin, and the product should contain no or negligible foreign content. And if you'd like to know more on how to make these claims, I recommend reviewing the FTC guidelines. Now, this time, let's talk about the label itself. So the statement of identity is the common original name of your product. It is the name that consumers expect to see on the label for a certain type of product, for example, rice or barbecue sauce. It can also be a descriptive term commonly used to refer to that type of product. For example, Pop-Tarts, which is a registered trademark, but the name of their product is toaster pastries. Now, some products' names are legally defined and are subject to government-established standards of identity. So the FDA established these standards to ensure that products labeled with specific names meet consumer standards and expectations. Basically, standards of identity tell us the ingredients and manufacturing processes that must be used to make a food product eligible to be called by a particular name. They help make sure that the food you buy is what you think it is. And so products like milk, cheese, yogurt, peanut butter, ice cream, etc. Are subject to standards of identity. So let's take peanut butter, for example. To be labeled as peanut butter, a food product must be primarily made from shelled and roasted peanuts, with a peanut ingredient constituting at least 90% of the finished product. The finished product may contain up to 10% of safe and suitable seasoning and stabilizing ingredients, such as salt, sugar, or emulsifiers. The finished product must not exceed a fat content of 55%, and artificial flavorings and sweeteners, chemical preservatives, and color additives are not allowed. So if a food product does not meet the standards for peanut butter, it cannot be labeled peanut butter. It would have to be called something else. You can still market your products, it just cannot be named peanut butter. So the net quantity of content statements tells you precisely how much product is contained in the container or package. For solids, the net quantity is expressed in weight, like ounces or grams, and for liquids, you'll find it in volume, such as fluid ounces or liters. The label also needs to include the metric weight quantity for complete accuracy. And you will find the net quantity statement in the lower third of the principal display panel. So the ingredient list. So all ingredients in a product must be listed by their common or usual name in descending order of weight from most to least. So if a product contains a multi-component ingredient, you need to list the ingredients that make up that ingredient separately in parentheses directly after that main ingredient name. For example, let's take a muesli breakfast bar. Muesli typically contains oats, dried fruits, roasted nuts, and added sugars. The ingredient list would include all these major food ingredients, along with the multi-component ingredients for dried fruits, let that be dates and figs, and roasted nuts, almonds, walnuts, and pecans, for example. Now, ingredients such as spices, natural flavors, or artificial flavors may be grouped together. They can be listed either by their common or usual name or collectively under the declarations spices, flavor, natural flavor, or artificial flavor. So for example, if a product contains a blend of spices, it may be listed as spices in the ingredient list. However, if a product primarily consists of spices, flavorings, or colors, then each ingredient must be listed by its common or usual name. And another important detail to note is that water added to a food product during processing must be listed in the ingredient list. However, if the water is completely removed from the food during baking or other processing methods, it doesn't need to be included in the ingredient list. So this one is pretty straightforward. The label must display the name and physical address of the company responsible for manufacturing, packaging, or distributing the product. However, unless the listed name is the actual manufacturer, a qualifying statement indicating the company's role in the production process, such as manufactured for company name or distributed by company name, must be added to the label. Nutrition facts panel. So a nutrition facts panel is a standardized label on packaged foods and dietary supplements and breaks down the nutritional contents of their product. It provides consumers with information about foods that are high in nutrients and the not so good nutrients such as saturated fat and added sugars. It enables consumers to make informed decisions about their food choices. So the FDA introduced in May 2016 an updated nutrition facts label and included changes to the format and content of that label. So the current label now shines the spotlight on calorie content and serving size by giving it more visibility on the label. The label also lists the amount of each nutrient in a serving of the food compared to the daily value. This includes total fat, cholesterol, total carbohydrate, and protein. Additionally, the label now includes information about total sugars. That includes natural and added sugars, along with the declaration of the added sugars below the total sugars. So the label also provides a breakdown of the intake of vitamin D, calcium, iron, and potassium per serving size, while vitamins A and C are no longer required to be listed after some data showed there is a lower incidence of vitamins A and C deficiencies among individuals in the general population. So the allergen information. So the Food Allergen Labeling and Consumer Protection Act requires that food labels clearly identify any ingredients that fall under the Act's definition of major food allergens, or that contain proteins derived from major food allergens. So food labels can either specify the allergens within the ingredient list, for example, flour, in parentheses, wheat, instead of just flour, or include a separate statement adjacent to the ingredient list that explicitly states contain allergen X. And these major allergens include milk, eggs, fish, crustacean shellfish, tree nuts, peanuts, wheat, soybeans, and since January 1st, 2023, sesame. So there are three types of claims that can also be displayed on food and dietary supplement labels: the nutrient content claims, the health claims, and the structure/function claims. So a nutrient content claim is a statement on a food product that directly or indirectly state the level of a nutrient in the food. For example, contain 100 calories or high in oat bran, or indirectly suggest that the food may be beneficial for your overall health. For example, healthy contains 3 grams of fat. So the FDA has outlined specific regulatory requirements for nutrient content claims. For example, the terms calorie-free, free of calories, no calories, 0 calories, etc. can be used on food labels if the food contains less than 5 calories per serving based on the reference amount customarily consumed. Another example, foods can be labeled as sugar-free, no sugar, or any similar statement if the food contains less than 0.5 grams of sugar and per label serving, and the food must not contain any ingredients that are sugars and that are generally understood by consumers to contain sugars. One last example, foods can be labeled reduced fat, less fat, or lower fat if the food contains at least 25% less fat per reference amount customarily consumed than an appropriate reference food. So the label must clearly identify the reference food and the percentage by which the fat content differs between the two products. For example, if reduced fat mayonnaise contains 25% less fat than regular mayo, the label must say reduced fat mayonnaise, 50% less fat than our regular mayonnaise. Additionally, the label must provide quantitative information comparing the fat content of the product per label serving with that of the reference food. So for example, the label could say fat content has been reduced from 8 to 4 grams per serving. However, be careful, the food cannot be labeled as low fat because the idea here is that the product is only slightly lower in fat than another product that is already high in fat. So as you can imagine, the rules for nutrient content claims are pretty extensive, so we won't be able to cover them all today, but I thought these 3 examples were pretty interesting. So a health claim. So it is a statement that suggests or implies a relationship between a food or substance in the food and a disease or health-related condition. So for example, diets low in sodium may reduce the risk of high blood pressure, a disease associated with many factors. So these claims must meet certain scientific standards and be approved by the FDA before being used on a product label. They are limited to those that support disease risk reduction and cannot claim to diagnose, cure, mitigate, or treat any disease. There are 2 types of health claims. Authorized health claim, which mean that there must be significant scientific agreement among experts that the claim is supported by a large body of scientific evidence linking a particular substance to a specific health benefit. For example, adequate calcium and vitamin D as part of a healthful diet, along with physical activity, may reduce the risk of osteoporosis. And qualified health claim, which do not need to meet the significant scientific agreement requirement, but must be supported by some scientific evidence. So they must be followed by a disclaimer to inform consumers about the level of scientific support for the claim. For example, scientific evidence suggests but does not prove that whole grains as part of a low saturated fat, low cholesterol diet may reduce the risk of diabetes too. So the health claim is not to be confused with the healthy claim. So the use of the healthy claim on food labels is voluntary. Manufacturers are not required to use this claim, but they can do so if their products meet certain nutritional criteria. And under the current FDA definition, food products labeled as healthy must have a limited amount of total fat, saturated fat, cholesterol, and sodium, and provide at least 10% of the recommended daily intake for one or more of the following nutrients: vitamin A, vitamin C, calcium, iron, protein, and fiber. So in September 2022, the FDA actually proposed to update the definition of healthy to reflect more of the latest nutritional science and federal dietary guidance, including the dietary guidelines for Americans. And under the proposed changes, food would need to contain a certain amount of ingredients from at least one of the 5 food groups or subgroups that the current dietary guidelines for Americans recommend as part of a healthy diet. The proposed definition would also require foods to be limited in certain nutrients like saturated fat, sodium, and added sugars. And also under the proposed definition, raw fruits and vegetables would automatically be eligible for the healthy claim due to their nutritional value and contribution to a balanced diet. So the comment period closed in February 2023, so we should expect to learn more about the final rule sometimes this year. So a structure/function claim can be found on the labels of food and dietary supplements and describes how certain nutrients or ingredients affect the body's structure or function. For example, calcium builds strong bones. So manufacturers must show that there is a reasonable basis for them to make that claim. Structure function claims are different than health claims because they don't make any claims about diseases. However, if a dietary supplement label makes a claim that suggests a relationship with a disease, the product will be regulated as a drug, unless the claim is an authorized health claim that has been reviewed and approved by the FDA. Now the other labeling claims. So we have the organic claim. So the term organic on food labels indicates that the product has been grown or produced using methods that are considered to be more sustainable and environmentally friendly. The FDA is now responsible for regulating organic claims on food labels. This responsibility falls under the authority of the USDA National Organic Program. So the National Organic Program establishes and enforces the standards for organic production, handling, and labeling, and the USDA is the agency responsible for certifying products as organic. So organic products are labeled under 4 categories. So you have 100% organic. So this label means that the product is made entirely with organic ingredients. Organic, which means that the product contains at least 95% organic ingredients. Made with organic ingredients, meaning that the product contains at least 70% of organic ingredients. And some organic ingredients, meaning that some organic ingredients are present in the product, but still the product does not meet the 70% organic ingredients requirement. And if you'd like to learn more about the 4 types of organic labels, please check out this link for a more detailed overview. Animal welfare claim. So food producers and manufacturers have the option of making voluntary animal welfare claims on their products, except for meat, poultry, and egg products. For this specific food categories, the USDA FSIS must approve these claims before they can be used. So here are some examples of animal welfare claims: humanly raised, cage-free, hormone-free, raised without antibiotics. So note that some animal welfare claims can be verified through a third-party auditioning process to ensure they are accurate, but many claims do not require third-party verification. The choice of whether or not to seek third-party verification rests with the product manufacturer. And the Food Safety and Inspection Service typically approve claims that have been granted by a third-party auditor or certification body. However, food companies are still required to submit appropriate documentation to the agency. So natural food claims. So the FDA has not yet defined the term natural for use in food labeling, but it has interpreted it as meaning that a food contains no artificial or synthetic ingredients that would not normally be found in that food. However, the FDA did not address food production methods or food processing or manufacturing methods and did not consider whether the term natural should imply any nutritional or other health benefits. So gluten-free, it is a term used to describe foods that do not contain gluten, which is a protein found in wheat, rye, barley, and crossbreeds of these grains. The FDA has set a strict limit of 20 parts per million of gluten for foods that can be labeled gluten-free. This means that it can be no more than 20 milligrams of gluten per kilogram of food. So in addition to the 20 ppm limit, the FDA also has rules about which ingredients can be used in a gluten-free food. Foods labeled gluten-free cannot contain ingredients that are any type of wheat, rye, barley, or crossbreeds of these grains. Ingredients derived from these grains and that have not been processed to remove gluten, or ingredients derived from this grain that have been processed to remove gluten, but the processing results in the food containing 20 or more ppm of gluten. So in August 2020, the FDA updated its regulations for gluten-free labeling to provide specific compliance requirements for fermented or hydrolyzed foods, which include yogurt, sauerkraut, pickles, cheese, green olives, beers, wines, and hydrolyzed plant proteins, which are usually used in processed foods. So the rule did not change the definition, but provided specific guidance on how manufacturers can demonstrate their fermented or hydrolyzed foods meet the 20 ppm of gluten requirements. So in December 2018, the USDA Agricultural Marketing Service established the National Bioengineered Food Disclosure Standard. This standard requires food manufacturers, importers, and certain retailers to disclose whether the food they offer for retail sale is bioengineered or contains bioengineered food ingredients. So the standard defines bioengineered foods as those containing detectable genetic material modified through in vitro DNA techniques and that cannot be produced through conventional breeding or found in nature. Now the disclosure must be made through 4 distinct methods: a text, a symbol, an electronic or digital link and phone number, or a text message. And there are 3 different locations where food companies must put a label saying whether their food is bioengineered. So one place is the principal display panel. If there is not enough room, the information panel. And again, if there is not enough room, any other location on the package. However, are not subject to the disclosure rule small food manufacturers with annual receipts below $2,500,000, foods derived from animals fed bioengineered feed, food and ingredients certified under the National Organic Program, and meat, poultry, and egg products, with 2 exceptions. So the disclosure standard would still apply if the most prevalent ingredient, so the first listed in the ingredient list, would normally be subject to FDA labeling requirements. For example, single ingredient raw ground beef would be exempt from the disclosure requirements, but a pepperoni pizza with any type of bioengineered flour as the first ingredient would be subject to disclosure. Or if the most prevalent ingredient is broth, stock, water, or similar ingredient, and the second ingredient would normally be subject to FDA labeling requirements. Okay, so now I would like to talk about the government efforts currently put into regulating the labeling of plant-based food and beverages that are marketed as alternatives to traditional food and drink options. So in recent years, we all probably noticed the progressive mass arrival of plant-based food products on our grocery store shelves. For some of us, these products have even become part of our day-to-day diets. And according to a 2021 report issued by Bloomberg Intelligence, global retail sales of plant-based food alternatives may reach 1.62 billion by 2030. or 7.7% of the expected $2.1 trillion global protein market. And their analysts also expect the sales growth for plant-based meat and dairy alternatives to surpass conventional products. And as I mentioned earlier, the FDA regulates the labeling of standardized foods and beverages, which have legally defined names and conform to government-established standards of identity. For non-standardized food and beverages, the FDA requires the use of their common original names. However, if the product's common original name is misleading, the FDA can establish a new standard of identity for their product through regulation. Now, the FDA has not yet done this for plant-based food and beverage alternatives. However, it provided in February 2023 draft labeling recommendations for plant-based milk alternatives to inform consumers, and also announced in July 2023 that it was considering working on some draft guidance for the labeling of plant-based meat alternatives. So this draft guidance on the labeling of plant-based milk alternatives came after the fast-growing market for plant-based dairy alternatives had the US dairy industry a little bit worried as consumption and sales of fluid milk beverages started to decrease in favor of plant-based alternatives. According to the USDA, there has been a persistent downward trend in US per capita consumption of fluid cow's milk, and the agency confirmed that the rise in sales of plant-based milk is competing with and is a factor in the decrease in sales of dairy milk, even if it represents only a small share of overall sales trends. So the dairy industry stakeholders, they have been pushing, the FDA for years to act on the proper labeling of plant-based milk alternatives and prohibit plant-based beverages from using dairy terms. One of the major arguments is that plant-based beverage companies, by marketing their plant-based dairy substitutes using the term milk, violate the federal standard of identity for milk and mislead consumers. But we'll come back to that in a few minutes, because first I would like to address the specifics of these FDA recommendations. So on February 22, 2023, the FDA published non-binding recommendations for the dairy industry on the labeling of plant-based milk under the Food, Drug, and Cosmetic Act and how to use voluntary nutritional statements. So to give you a little bit of background, in September 2018, FDA already thought comments on the labeling of plant-based products with names that include dairy food names, such as milk, cultured milk, yogurt, and cheese. FDA wanted to learn how consumers use and consider plant-based foods and how they perceive terms like milk and yogurt when in combination with the names of plant-based products. FDA specifically thought comments on the current market conditions and labeling cost of plant-based products, consumers' understanding of plant-based food characteristics and physical properties and nutritional values, and the role of plant-based products and dairy foods in meeting the recommendations in the government dietary guidelines. And FDA received approximately 13,000 comments. Upon reviewing these comments and data, FDA identified a potential public health concern concerning the substitution of dairy milk with plant-based milk that may contain lower nutrients than cow's milk. And as a result, FDA chose to focus its recommendations solely on the plant-based milk alternatives. So the FDA acknowledged that consumers understand plant-based milk as distinct products from cow's milk, and noted that such products have various common original names and may be labeled with the term milk. However, the FDA emphasized that the term milk should be qualified by the plant source of the food. So for example, soy milk or oat milk. And that it would not be appropriate to use terms like plant-based milk or dairy-free milk, as they do not describe the nature of the plant source and do not differentiate the products from other types of plant-based milk alternatives. FDA also observed that several consumer studies indicate a lack of understanding among consumers, including those who purchase plant-based milk, about the nutritional differences between cow's milk and plant-based milk. As a result, FDA recommends that plant-based milk alternatives with different nutrient compositions from cow's milk should have an additional nutrient statement on the product label describing these differences. So, for example, a product label stating contains lower amounts of vitamin D than milk. And FDA also suggests that the voluntary nutrient statement be prominently displayed on the label to ensure that it is easily identifiable for consumers. So the public comment period for that draft recommendations ended in April 2023, and FDA received a total of 922 comments. So now let's talk about deceptive food labeling. So food labeling regulations are designed to protect consumers from being misled or deceived about the product they buy. And under the Food, Drug, and Cosmetic Act, only safe and properly labeled food is allowed to be introduced or delivered for introduction into interstate commerce. In addition to the FDCA, other federal statutes, so the ones governing the labeling of meat, poultry, and egg products have similar provisions protecting consumers by prohibiting misbranding of labels. So a food product is deemed misbranded when it fails to meet certain labeling and packaging standards. This includes providing false or misleading information, using deceptive names or containers, and not complying with regulations regarding ingredient disclosures, quantity statements, quality standards, and special dietary use claims. Now, an important point I'd like to make is that mislabeling and misbranding are indeed both forms of inaccurate product labeling, but they have different meanings. Mislabeling refers to mistakes in the information on a label. So, for example, the product label does not list all ingredients. A food product is labeled as natural but contains added sugars and flavors, or the product label uses a font that is difficult to read. Misbranding, on the other hand, involves making false or misleading statements about the product, such as claiming it has benefits it does not actually have. So, for example, a food product advertised as organic, even though it is not certified organic, or a product label made in USA when it actually contains foreign ingredients. So the law provides that a food is misbranded if it contains inaccurate or deceptive information about the product. So let's talk about the different legal reasons why a food product is considered misbranded. So a food product is considered misbranded when it is marketed with a name that is misleading to consumers. So in this case here, the plaintiff alleged that defendant's use of the term hoisin to label its sauce product, which literally translates to fish or seafood in English, was deceptive and misleading to consumers. The plaintiff argued that the use of this term led consumers to believe that defendant's sauce contained fish or seafood. And the federal district court found that plaintiff's arguments without merit, explaining that the fact that defendant's product name does not contain fish or seafood does not make the product misleading. And I quote, because many sauces are not named after the ingredients, but are named after the foods they accompany. And the court gave the example of steak sauce, which actually does not contain steak. And the Second Circuit Court affirmed that district court's judgment. So another reason why a food product would be considered misbranded is if it imitates another product unless stated as such on the label. So in this case, the US government claimed that the product Delicious Brand Imitation Jam, which was manufactured in Colorado, was mislabeled as jam because it does not meet the federal definition of jam, which requires a minimum of 45% fruit content. And the product in this case contained only 25% fruit, with the remaining being sugar, pectin, citric acid, and soda. So the Federal District Court determined that the labels on the jars were essentially accurate. The court concluded that since the product was only labeled as an imitation fruit preserve and met all the requirements under the Food, Drug, and Cosmetic Act, it could not be considered misbranded. The Federal Appellate Court, however, found otherwise, ruling that the product was misbranded even though it was clearly labeled as imitation. The court based its decision on the fact that the product was similar to fruit jam in both appearance and taste and was used as a substitute for it, which suggested to consumers that it was indeed fruit jam despite the imitation label. So this case went before the US Supreme Court, which concluded that the product was indeed, not misbranded, highlighting that the name imitation jam at once connotes precisely what the product is. I quote, a different and inferior preserve not meeting the defined specifications. Another reason why a food product would be considered misbranded, the packaging misleads consumers about the contents of the product. So for example, a container that is filled with air to make it appear larger than it actually is could be considered misleading because it deceives customers about the product's true quantity. So I have listed here 3 cases. In the first one, the customer expected to get a full box of Fleshman's Simply Homemade Baking Mix cornbread, which came in opaque packaging. But when he opened it, he found that the container had more than 50% empty space or slag fill. So this case was dismissed with prejudice after both parties reached a settlement. In the second case, the plaintiffs alleged that Tootsie Roll Industries used deceptive packaging practices to maximize profits at the expense of consumers. The company allegedly sold opaque theater candy, Junior Mints, and Sugar Babies products that failed to adequately inform customers about the amount of candy they were actually purchasing. The plaintiff referred to this practice as slag fill, and the court ruled in favor of the defendant, finding that the net weight of the candy, both in metric and standard measurements, was clearly and prominently displayed on the front of the product packaging. And the court determined that this information is sufficient to inform a reasonable consumer about the amount of candy they are purchasing, and therefore does not constitute deceptive or unfair packaging practices. And in this last case, the plaintiff alleged that the defendant intentionally used deceptive packaging practices for its Annie's homegrown brand cereal products, resulting in containers containing approximately 30–50% empty space. Again, the court dismissed the case, holding that the packaging was not deceptive because the cereal was sold by weight and the number of servings was clearly labeled on the packaging. All right, so I'll try to go fast. So a food product is also considered misbranded when the label does not include essential information, such as a complete ingredient list or a clear quantity statement, or the product's ingredients and composition do not meet the legal requirements for its standard of identity. In this case, which actually established precedents, the court ruled that products that claim to be standardized but contain ingredients that are not recognized by the standard of identity or misbranded, regardless of whether the label actually accurately lists the ingredients. So now I would like to draw your attention to plant-based labeling litigation. As I have mentioned earlier, the dairy industry's argument is that using the term milk to market plant-based dairy alternatives violates the federal standard of identity for milk and misleads consumers. And I'm going to go quickly here, but in the 3 cases listed on this slide, plaintiffs, all purchasers of different lines of plant-based milk, alleged that the use of dairy terminology on this product's packaging suggested to consumers that those products were equivalent to dairy milk and as a result violated the FDA standard of identity for milk. Plaintiffs claimed they would have refrained from purchasing these alternative products had they known their products were not comparable in terms of quality, taste, or nutritional benefits to actual dairy products. So the defendants, sorry, I have to move the, I cannot move the poll. Yeah, sorry. So defendants counter-argued that a reasonable consumer could not be deceived into believing that any sort of plant-based milk alternatives has the same lacteal properties than dairy milk. So the courts dismissed the three cases. They clarified that the standardization of milk simply means that a company cannot pass off a product as milk if it does not meet the regulatory definition of milk. However, in these cases, defendants did not call their products milk, but instead called them soy milk or almond milk, and as a result, properly conveyed the basic nature and content of the beverages while clearly distinguishing them from dairy milk. In another case, Miyoko's Kitchen versus Ross, this time dealing with plant-based butter, Federal District Court in California ruled that Miyoko's Kitchen could use dairy terms like butter to describe its vegan product on packaging. A little bit of context, in December 2019, the California Department of Food and Ag asked Miyoko's to review its label cultured vegan plant butter to comply with federal and state regulations because the product was not butter as per the federal definition of butter. So later on, Miyoko's filed a lawsuit against the State Department under the U.S. Constitution's First Amendment, challenging the regulatory authority of the state and arguing that such action does suppress freedom of speech and in no way does provide any service to the public against deception. So the state argued that the federal definition of butter, which was initially enacted in 1923, reflects what consumers believe is butter. So the court agreed in part with Miyoko's and held that, I could quite simply, language evolves, and rejected that the 90 years old federal definition bears heavily on consumers' understanding of butter. And for that, the court ruled that the state cannot restrict Miyoko's use of the term butter on the label. So even though these federal cases do not constitute precedent outside of the federal district courts of California, they are a good indication as to how potentially other courts could interpret FDA's standard of identity for milk and other dairy products. Now, coming back to our food misbranding. A food product is considered misbranded when a food product advertise claims about quality or quantity or not supported by accurate information on the label. In the case here, the plaintiff alleged that the company's granola bars are falsely advertised as containing primarily honey, when in reality they contain more sugar than honey. The plaintiff claims that the front label of the bars prominently features the words oats and honey and a dripping honey dipper, suggesting that honey is the primary ingredient. However, the plaintiffs maintained that sugar is listed as the second ingredient after whole grain oats, indicating that it is the dominant sweetener. So the parties reached an agreement and the case was voluntarily dismissed. Another reason why a product would be considered misbranded is if pasteurized food products do not clearly indicate that they have been pasteurized. Or that food products marketed for specific dietary needs make misleading health claims without providing clear nutrition information. In this case, the plaintiffs alleged that the company's marketing materials misled consumers into believing that glass-sold vitamin water is a nutritious and healthy drink when in reality it contains a high amount of sugar. So the parties reached an agreement, resulting in Coca-Cola making modifications to its vitamin water labeling guidelines. A food product would also be considered misbranded when food products fail to disclose the presence of artificial flavoring, artificial coloring, or chemical preservatives. an important thing to note is that more and more consumers have brought legal action against food and beverage companies over deceptive, all-natural claims about their products while they contain additives or preservatives. In that first case, consumers filed a lawsuit against Wegmans in New York, alleging that their product, vanilla cake mix, was mislabeled as naturally flavored when it actually contained ethyl vanilla, allegedly considered an artificial ingredient. So the court dismissed the lawsuit because the plaintiff's claims lacked any credible evidence to support them. It concluded that the plaintiffs failed to demonstrate that ethyl vanilla is not derived from natural sources. Similarly, in the second case, the plaintiff alleged that the all-natural labeling of a mango peach beverage was deceptive because it contained DL malic acid, which is a form of malic acid that is often produced synthetically. So the federal district court dismissed the lawsuit, holding that the plaintiff's allegations about the presence of DL malic acid were based on mere speculation, lacking any concrete evidence from product testing. So you see here that plaintiffs struggle to provide clear and convincing evidence to support their claims, and it may be due to the fact that there is not yet a definition of what a natural food product is. And then to my last slide to finish, a food product is misbranded when food products fail to disclose the use of any pesticide chemicals applied after harvest, and when food products packaging and labeling fail to meet regulatory requirements for color additives and pharmaceutical labeling standards. Now, for a more comprehensive understanding of food labeling disputes, I strongly recommend consulting our partners, the National Ag Law Center, Case Law Index Food Labeling. They have done such a great job comprehensively documenting food labeling cases from 1995 to 2023. Okay, Audrey, that's a wrap. Thank you all for your attention. I know this is a lot to digest, and I will now do my best to answer some of your questions.
Excellent. Thank you. So that was great. We do have just a couple questions and we have just a few minutes left. So perfect. The first one is honey a liquid or a solid?
Sorry, say that again.
Is honey a liquid or a solid?
It's a liquid.
And that's, this person says it's listed by weight as solid, but technically there's Brooke just posted a PDF here, and FDA uses a dictionary definition in which it refers to as a liquid. So I would say,
yeah, that's
but I mean, it's all sold by weight too. So, Mr. Puzak asked, is there any exemption for small family farms from some of these requirements? For example, homemade jelly cheese, and is there a sales or production threshold? Do you know of?
No, unfortunately, I don't know them. Like I said, there are a lot of rules, a lot of exemptions, exceptions. However, I'll be very happy to look into it. And if you, want to share your email address with Audrey, then I'll make sure to answer you.
Perfect.
Audrey, I can answer that.
Oh, I'm sorry.
I can answer that one for Dave Puzak. Just briefly, the FDA level, there are no exemptions for small operators. That's left to the states. So then the states have their cottage food is sometimes the terminology that's used for it, where they make exceptions to the general setup of the food code for smaller operations. Pennsylvania calls them limited food establishments. And if you go to the PDA, Bureau of Food Safety website, you'll see there are some relaxation on very limited numbers of labeling requirements for what's called limited food establishments in PA, or look in your individual state for generally things like cottage foods. That seems to be the term that most states are using nowadays for that for smaller operators who might get some kind of exceptions.
So cottage foods, right. We are at 1 o'clock. So if you need to jump off, we understand if you got to get back to work. We have a couple more questions. We'll finish up here if you want to hang on and listen. Mr. Agnew says, well, Chloe, you talked about some of the challenges to some of these laws. How rigorously are the requirements policed, and are they policed? How are they policed?
You mean?
So FDA regulations, how rigorously are they policed, and then how are they policed?
I'm not sure I'm understanding the question.
So,
I can address it a little bit, Audrey.
sure.
From the state government level, since people are aware that that's where I worked for many years, it's mostly complaint based, to be honest with you, and that is in a lot of ways what the right answer would be, even at the FDA level, because resources just dictate that, and so there's no question that it sometimes is one commodity seller complaining about another commodity seller's labeling, or formal complaints filed at the agency level that are more in the way of public, petitions, for example, of FDA to change something like that butter case, in California. That was the subject of a long petition that was an internal FDA. So anyway, it no question, it does get a little bit it's not the highest priority, let's just put it this way, to go out and be scouring the supermarket shelves.
Fair. So I would say, so somewhat rigorously, but there seems to be more of a, like a private, people bringing their own complaints there. And then in the mislabeling cases, were private plaintiffs or government actors?
So most of the time they are private plaintiffs, though in the case I mentioned from the US Supreme Court, the plaintiff was the US government. But that's a case that dated back to the 50s, I think. But yeah, all the cases I've come across, private plaintiffs.
It seems like there's, some incentive for other companies to, sue. Right. And then we've got one more. So this would be kind of on the claims, making claims. Can you say a product is high in protein?
You could, but then you would have to be able to support that claim. So, how high in protein is your product, probably with some comparable elements to that claim.
Right. And I think just that statement, high in protein, like you're not saying that the protein's doing anything. You're just saying.
Yeah, that it just has a higher protein content compared to another product. Yeah.
Right. All right, those are all the questions. If you have any specific questions, you can send them to me or Chloe. Her address is on our website there. Other than that, thank you all so much for joining us. Oh, let me get this up. And our next webinar is February 13th, which is actually our dairy quarterly webinar. And then our next understanding is going to be the end of February with understanding clean and green separations and split offs. So we hope to see you all there. And with that, we'll say goodbye. Bye all.